we are praying that directions be issued to the appellants, like the respondents in the said case. Respondent number 2 in this. Directing the respondents, directing the appellant and respondent number 2, arrayed as respondents in the said bracket, arrayed as respondents in the said petition, to refund the differential GST amount paid by the petitioner in respect to the works executed by them. The prayers as made by the petitioner and as reproduced in the impugned order set out below. The learned single judge, without adverting to the facts, allowed the said petition by referring to the decision rendered in WP 9271 of 2018 and other connected cases. Bracket that Chandrasekhara and others versus State of Karnataka. Footnote 2020 neutral citation 2023 KHC 1415431. The appellant's signature is directed the appellant and respondent number 2 to reimburse the GST amount as claimed in the representation dated 21/11/2024. The said representation is being placed on record.
One request,
has been placed on record, which indicates that the petitioner had raised various writ petition. One had raised various bits of in respect of construction of DC Post Matric Girls Engineering Hostel at Kadwa, Uttar Kannada, under a contract agreement dated 28/2/2018. It's also stated that the petitioner had paid, the writ petitioner had paid CGA, an aggregate CGST amount paid amounting to rupees 12,99,699 and SGST of rupees 12 from the equivalent amount. The petitioner stated that since the contract was executed after 1/7/2017, on which the GST regime was rolled out, was entitled to reimbursement to this. Next slide. The brief facts are that the appellant had invited tenders on 25/10/2017 for execution of certain works, bracket construction of Construction of PC post-metric girls engineering hostel at Kadwa, Uttar Kannada district, bracket close. On 25/10/2017, the tenders were opened on, or this is the writ petitioner participated in the tender, which is tenders, and was declared a successful bidder. The contract was awarded to the writ petitioner on 8/12/2017. That is a letter of acceptance.
Letter of the work order, Manoj, is 28th of February 2018.
No, that's a contract about the.
Manoj, kindly see page 38 in the reference portion. All the dates are mentioned there. Page number 38. Tender notification number so and so dated 25/10/17. Tender dated so and so. Proceedings of the meeting dated 10/1/18 and agreement dated 28th February 18.
Page 38.
Page 38, that's right. That's the work order. In the reference portion, the dates are mentioned.
Yes. 25. This is the writ petitioner that submitted his tender on 8/12/2017. The same was evaluated and the writ petitioner was declared a successful bidder. Thereafter, the parties entered into an agreement dated 28/2/2018. The work order, the said agreement indicates that the appellants had accepted the petitioner's bid for execution and completion of the works and remedying all defects within the defect liability period at a contract price of rupees, put a quote, contract price of rupees 3,17,41,000, bracket rupees 3,17,41,000 only, bracket close, unquote. Then bracket open, plus 1.48% above SR 2016-17, bracket close. It is apparent from the above that the contract was executed, that no part of the work was executed during the period prior to 1/7/2017. Prior to the rollout of the GST regime, that is prior to 1/7/2017. Full stop. Thus, we are unable to accept that the decision in the directions issued in the case of Chandrasekhar Iyer would be dash, which is the sole basis on which the writ petition is allowed, dash, would have any relevance, would have much relevance.
Well, sorry to
without going into this, it's also not necessary to go into the third question because it is clear that the dispute whether the writ petitioner is entitled to GST, reimbursement of GST paid by it or not, the matter of contractual disputes. The impugned order does not indicate that any of those said dispute is being examined or adjudicated.
It's a humble request to remand it back to the single judge.
Yes.
So that
View of about the petition is allowed. It will clearly also not be apposite to examine such disputes in the writ petition. In proceeding under Article 226 of the Constitution of India. The petition is, the appeal is allowed. The impugned order is set aside. The appeal is allowed. The aforesaid. How we clarify that the appeal is allowed and the impugned order is set aside. How we clarify this will not preclude the appellant or the parties from availing their from availing the remedies, substantive remedies in accordance with law.
My lords, I've referred to another judgment also, my lords. Apart from that judgment, my lords, writ petition 107489 is also there of 24, page number 17 and 16.
The learned counsel is also referred, or the respondent also referred to our decision in writ appeal number 71/2025 bracket T-RES, whereby the said appeals against and writ appeal number 615/2025. Permits to the said appeals were allowed in the orders which were passed in similar terms as the impugned orders had been set aside, albeit to a limited extent, of clarifying that the directions contained in the directions contained, bracket, which was similar to the directions delivered in Chandrasekhar Raya Supra, bracket close, be construed only as a direction to the employer, capital E, and not to the tax authorities. We submit that therefore the direction for the employer to, bracket, which in this case is the appellant, bracket close, has been, bracket close was being affirmed. So the said contention is not merited. The said appeals were filed by the state authorities, by the tax authorities, claiming that directions issued were beyond the scope of the relevant statutes. In that context, this court had clarified, they allowed these said appeals by clarifying that in any event the directions issued in Chandrasekhar Raya and other decisions that were followed where similar directions have been issued would not be construed as issuing any directions to the tax authorities. This did not in any manner preclude the employers from contesting, the contractual parties from contesting, concerned employers from contesting the orders passed. Full stop. Which is the next one?
The second appeal, my lords, same employer, only one small difference. Tender notification is 18th of November 17, but that also is after 177. That's the only change. Otherwise, the date of submission of tender and everything else is the same. Date of agreement also will be the same. 18/11/2017 is the tender notification, as opposed to 25/10/17. This is 18/11/17. All the other dates are identical.
Same work order. Similar work order.
Same, identical.
No, that must be
different work, my lords, different work, but different tender notification, but the dates are identical. That's all.
Then 10.2.
My lords, but the single judges relied upon other judgments also in this, apart from Chandrasekhar.
Single judge is required, as relied on no other judgment. Just copied the direction by saying this is covered. It's not covered, first of all, and that decision we have already.
But my lords, respondent has paid the GST, my lords,
yes,
because there was a.
Whether you're entitled to GST or not entitled to GST reimbursement from the employer is a matter of contract between you and the employer. How does it come into the conclusion whether GST has been rolled out? Obviously, you have to pay GST. There's no dispute about it.
But my lords, in other departments, my lords, if you take GTDC, PWD, APMC, my lords, even the clause was not mentioned of the GST inclusion. They have paid, my lords, the initial GST component.
It's purely a matter of contract between you. You have to establish that your contract entitled you to reimbursement.
My lords, in the other case also, there were not such clauses wherein it was.
Whenever the cases come, we'll set aside these orders like we've been doing. We've already set aside I don't know how many orders. We'll do the rest also. What is 11 now? 10.2.
10.2, my lord.
Let's
Be excused, my lord. Lordships, excuse my presence.
Yes.
Let's the tender date is 2/1/2017, my lords. The agreement date is 23/9/2017, my lords. Post GST. Work order is issued 6/10/2017, my lords.
Work on. Is there any other agreement?
No, my lords. No.
Is there a tender notification here?
Well, its tender notification was 2/1/2017, my lords. In fact, it's page number. The work order, in fact, my lords, is at page 33, my lords. Notice to proceed with the work. That details out the dates, my lords. The agreement is 23/9.
Okay, we pass a similar order. We pass a similar order. I'll just say for the reason. Is it dismissed? Is it out? $208 delay. This is your matter.
My lords,
This is our matter, my lords. That's the deal.
This item number 10.2 is the chief manager,
Chief manager, chief engineer, chief manager, my lords.
Karnataka Housing Board.
Housing board, my lords. Chief engineer, my lords. It's 208 days delay, my lords.
Chief engineer. Incorrectly mentioned in the list. We'll allow this. Appeal as well. What is the condonation of delay? We'll say for the reasons stated in the application, the same is allowed. All three.
Serial number 23, 61. I'm appearing for the appellants, my lord. My lord, in these rate appeals, my lord, we are challenging the interim order passed by the learned single judge staying the election process, my lord.
They are agreeing. to
Please,
the
my lord.
being
Your
set
lordship may
aside.
kindly direct the returning officer to continue the election process from where it was interrupted, my lord.
From the stage where it was interrupted.
Yes.
I'm the petitioner my lord, on this matter. They are saying no objection. My entire case is not the amendment at all. My entire case is that I have not been permitted to vote or contest because the membership has been allowed by the registrar. That is the case.
You have not filed an appeal.
This is my petition itself, my lord. Appeal has been filed against my petition.
No,
First
appeal
one.
may have been filed against your petition. Appeal is against the order.
But in the order, my order has been considered along with the connected matter. Connected matter pertains to the amendment of the provision. My matter pertains to the fact that I have not been permitted to vote or
So where is the direction as far as you're concerned?
No, para number 17 of the impugned order pertains to my petition.
Yes.
DC page 59 deals with my petition. Para 17. If I'm permitted to vote and contest, no, I have no objection.
We don't know now whether it's a. There are two writ petitions, 833.
Petition, no, in my petition pertaining to Liquor Federation, my membership was confirmed. Subsequent to confirmation of my membership, they did not permit me to contest. For which reason I filed a petition seeking a direction, because once my membership was confirmed, they could not prevent me from contesting. This aspect has been confirmed by the learned single judge at para 17 of the impugned order. In the light of the submission made by the learned counsel appearing, that's from there. Internal page 12 of the order.
Yes. Well,
This is the only paragraph which deals with my grievance. In the light of the submission made by the learned counsel appearing for the parties, it is not in dispute that the petitioner society in WP number so-and-so is a member of respond number 5 federation. Perusal of the order dated 9/2/2006 in appeal number so-and-so makes it clear that the membership of the petitioner in the respond number 5 federation is confirmed. It is also to be noted that the petitioner society has followed the rules as to the payment of requisite fee towards membership of respond number 5 federation. It is also not in dispute that the calendar of events has been issued on so-and-so date to conduct elections to respond number 5 federation. The subsequent contentions are pertaining to the amendment.
no, so but where is it said that you should be allowed to vote?
Because the interim order only stays the election, but there is no finding apart from this pertaining to my grievance that I should be permitted in light of the order granting me membership. The order is at Annex 3A. The type copy melody is at page 71. There is no stay of this order. The only grievance of the Federation why they did not permit me was that I was restricted to certain districts. But 3 years ago itself, my bylaws have been amended pertaining to the entire state. So they cannot have any grievance in not permitting me to contest. This aspect has been confirmed, NEC page 75.
No, in this, we are only looking at your writ petition. Writ petition doesn't matter. The impugned order doesn't mention that.
The impugned order does not state so, though my petition states so. While seeking an interim order, I had both grievances. One is the amendment and one is the fact that I am not being permitted.
So you are only the impugned order only proceeds on amendment. We'll restore your petition to the learned single judge.
If elections go on, they will not be permitted to vote. Their entire grievance.
If you are to get your voting rights, you'll have to urge it before the learned single judge.
I may be permitted to do so.
Yes, we'll permit you. We are not foreclosing.
My lord, one more submission, my lord. The earlier term of the earlier governing body expires on 28/3/2026, my lord.
Yes.
But that governing body continued in operation by virtue of this interim order, my lord. Kindly come to the page 43, my lord.
In any case, now you are only giving the fundamental premise doesn't survive. If you want, we'll set aside the order and restore the writ petition.
Please, my lord.
The appellant has filed the present appeal, including a common order dated 8 March 2026 by the learned single judge in writ petition number 8337 bracket CS-EL/M bracket clogged with writ petition number 6945 of 2026 bracket CS-EL/M.
May I make one submission with permission? I am representing the Federation, my lord. As on the date of granting an interim order by the learned single judge, the election calendar of events was already issued. The nomination papers was already submitted, and there was also scrutiny was also held. But before 2 days prior to the election, the interim order was issued. Therefore, the election was stalled at the stage of publishing the election, my lord, conducting the election. Therefore, I most humbly praise the honorable court, my lord, to continue the election where it is stopped, my lord.
We have also no objection. Only thing is the last but one para, my lord, learned single judge says, till then, my lord, the present body can continue. That portion may be continued, my lord.
The term is already over, my lord, on 28/3/2026.
order date. By virtue of the said order, by virtue of the said interim order, the learned single judge had restrained the conduct of elections of the Federation. As well as the notification and calendar of events dated 3/3/2026. This plain reading of the said order indicates that the same is revised on the basis that section 28A of the Act and not being followed. Act, Karnataka Cooperative Societies Act, 1969. The learned counsel for the party state that they said premise no longer survives, as they said that section 28A, which was introduced by virtue of the Karnataka Cooperative Societies Amendment Act 2025, has since been stayed. As a notification dated 12/9/2025, notifying the Karnataka Cooperative Societies Amendment Act 2025, whereby section 28 had been introduced in the Act has been stated. Since the fundamental premise on which the interim order is granted does not survive, the same impugned order, the present appeal is allowed and the impugned order is set aside. The parties are at liberty to, the elections that have been stayed would continue from the stage as interdicted. However, we clarify that this would not preclude the parties from claiming any interim relief if so advised in the pending writ petition.
This one last, but one para says, till the elections are held, the same body can continue.
That's why we said you go and
Para 27 is
can't
there.
get the benefit of one and not the other.
Can I request for my interim relief to be considered before elections proceed?
No, we said you are free to go. You'll have to move the learned single judge. We granted you liberty.
Grateful.
List number 2, seal number 14. So Viresh.
Respondent, please, my lord.
Yes. On the interest part, they've now got the bank rate. You have to make any submissions on 13%.
I'm the safe hands of your lordship, my lord. I will only, as far as the interest is concerned. But the duration also is well reasoned, my lord. So why only that particular duration? The rate of interest, my lords, I'm safe hands of your lordships, my lord. I'll bow down.
No, rate of interest is as under the MSMED Act.
Please, my lord.
So we'll set aside the interest rate and leave it to.
Please, my lord.
This is to agitate the question whether interest rate under the MSME Act is to be.
Please, my lord. Please, my lord.
This we'll pass an order. We'll set aside this so far as the interest is concerned.
Please, my lord.
Well, since the matter is being remanded back to the arbitrator.
So we're not remanding it back. There can't be any remand. You can, unless we, on interest, you can re-agitate the matter.
Also like to place one citation on record, my lord, Calcutta High Court. As far as interest is concerned, rate of interest cannot be fixed by the arbitrator or by this honorable court under MSME Act, because monthly, every single month which is not paid, whatever is the interest applicable to that month is applicable. Therefore, it is for the executing court to decide, calculate. So the arbitrator and the honorable court should not have to go into a detailed calculation.
This is possible. Call the next. Hmm? 60. No, it's a lot. It is disposal. Just say for the, in view of the above, the impugned award to the extent that as to the interest awarded is set aside. The appellant is at liberty to re-agitate the same in arbitral proceedings, in arbitration afresh.
Yes. Still number 16.
Yes.
Reasons to follow. Very, very simple.
That's
This.
Serial number 16 and 16.1. I'd address my arguments, my lords. The issues which I framed at given my written submissions. One was the issue whether supplementary lease deed was required. The other was even if it is not required, or if it is required, carrying on mining operations cannot be termed illegal once there is a deemed extension.
Yes.
The other one was royalty issue, which they have to. Now 16.3 is another matter, my lords, where, my lords, a tender was issued.
16.3, my lords.
Yes,
In
it's connected.
16.3, it's a different matter with regard to different mining area.
No, it is a mining area, but tagged on the
Tagged
reason
on,
for
but it has to-
non-execution.
Lords, it has to be, we have not even filed statement in that. 16, 16.1 and 2 minutes are all connected.
16, you have to file a statement.
We have filed 16, 16.1 and 16.2 minutes. It is ready for disposal. 16.3 minutes, they have tried.
Because 16.3 is where they had to execute the MDPA. But, my lords, they have, because this issue is pending, they have refused to execute the MDPA and the mining lease.
First,
So
we'll argue this.
It may have to follow this.
Please, my lords.
We'll argue this.
Very well. 16, 16.1. Your lordship may decide on that. Because the state government has clubbed. We have not clubbed the issue.
State government is clubbed.
No,
It
they
is
have
a
got it-
state.
They have got it connected. Now they are saying that we have
No, the
connected.
issue-
We have, my lord,
Said you got it connected.
The issue is, the issue, they have got it.
no, I'm told, I get it. We have linked the issues.
You're not deciding it.
Please.
Yes.
That's with regard to execution of a supplementary lease deed, my lords. The word supplementary is used, my lords, but I would put it this way. In terms, though there is a deemed extension under 8 capital A5, that's the extension is in respect of the period, but for the purpose of carrying out the mining operations, there has to be a valid lease document, a lease deed, a registered document. Now they had a lease deed, my lords, still. (19 to 2023) deemed extension, my lords, that we have granted, that is in principle approval. I will put it this way, my lords. The approval that we have given for extension is in principle subject to certain conditions.
Yes.
My lords, may kindly see the document, my lords, that was read on the last occasion.
You're using the file of 16.2. Which file are you using?
No, it's for that deemed extension document, Manoj, it is at 18655 is 16.1. 16.1. 16.1, page 71. Manoj.
Yes.
But I'll just read this document. It's a subject. Minutes of 71 minutes. Proposal for deemed extension of lease period for 50 years from the date of original grant under section 8A of MMDR Amendment Act 2015 in respect of ML 2641 for limestone shale clay over an extent of 471 hectares in so and so villages of Chittapur Taluk, Kalburgi district in favor of so and so. Now kindly see the preamble minutes. The mining lease bearing ML number 2641 in parts in so and so villages of Chittapur Taluk, Kalburgi district has been granted in favor of Measures Associated Cement Corporation Limited for limestone shale and clay over an extent of 471 hectares for a period of 20 years, and the lease date was executed on 19/2/1963. Second para is important. The state government issued a standard operating procedure on 17/12/2015 for preparing perusal to accord consent of the government for deemed extension as per section 8A of the MMDR Act 1957. Accordingly, the Director, Department of Mines and Geology, via a letter headed so and so, has submitted report as per standard operating procedure along with the prescribed checklist, duly signing on each page of the pages. Now I'll skip minutes. The next they've extracted now kindly see the operative portion, page 72. Government order number so and so. In the light of the facts and circumstances mentioned in preamble and as per the provisions of section 8A5 of MMDR Act 2015 and 8A2 of KMMC Amendment Rules 2021, ML number so and so for limestone, shale and clay over an extent of 471 hectares in so and so villages of Chittapur Taluk, Kalburgi district granted in favor of so and so, extended up to 31/3/2023 for the period of 50 years from the date of original grant with the following conditions. 1. The Director, Department of Mines and Geology is directed to execute a supplementary lease deed subject to submission of necessary statutory clearances and NA all arrears payable to the government and all terms and conditions of the lease. The deemed extension shall not absolve the lessee or any other person claiming to the original concessionary from payment of any dues, royalty, dead rent, surface rent, fine, compounding charges, environment protection fee, energy dues which are due to the state government from such lessee or any person claiming through him or the erstwhile concessionary lessee for their acts or omissions prior to this letter. Number 4. No mining operations shall be undertaken in the leasehold area unless all statutory clearances, such as forest clearances under Forest Conservation Act, Environmental Clearance and Environmental Protection Act, KSPC consent permissions under various legislations, rules and notifications as amended from time to time to the satisfaction of the concerned authorities are in place. The lessee shall abide by the terms and conditions laid in the Act and rules and in this letter and conditions stipulated in the original lease deed. The lessee shall comply, kindly 6 minutes. The lessee shall comply with the provisions of the stamp duty and registration fee as applicable under the Karnataka Stamp Act 1957 and amended from time to time to satisfaction of the concerned authority under the Act. This deemed extension is subject to any independent proceedings under MMDR Act, including proceedings for violation of any provisions of the rules made thereunder. But my submission is this is an in principle approval for a deemed extension. Now, our contention, my lords, is that without a lease deed, by whatever name we call it, for that extended period, we call it a supplementary lease deed, or for that period, for the lessee to enter into the property, my lords, and carry on mining operations, there is a requirement of a registered document, registered lease document. This I get it, my lords, from this is, my lords, mining lease has been held to be a compulsory leaseable document. It partakes the lease of under section 106 of the Transfer of Property Act. There is a judgment to that effect.
The judgment to the effect that execution of a lead is a ministerial act in cases.
No,
Gujarat pottery is Gujarat. So.
No, it is a ministerial act, but the Supreme Court has held that unless you have a lease deed, you cannot. The fact it will not under section 49. If it is not registered document, it will not affect the land. You could not have entered the land lawfully. That is the judgment I'm relying upon. Can I just pass on that compilation?
Here is it says it's a deemed, these are statutory. So first of all,
Yes, I get it, but
your
it's,
approval or non-approval in a scheme where there is a deemed extension
Please.
by the statute, how does that apply?
lords, that will apply because
No, I don't approve.
lords, that is because 31 of common cause. My lords may see 31 of common cause for a moment. My lords may kindly take the compilation that they had passed on, because after referring to, this is the compilation, my lords, that the petitioner have given. After referring to the concept of deemed extension, still the Supreme Court says, petitioner in 18655. There is also a stamp duty implication notes. I'll just point out. It's running page 24. 24 at para 31. Notes, the other paragraphs where the other side have already read it. My lords may see, irrespective of the position noticed herein above, that is with regard to the deemed extension, it is imperative for us to clarify that the benefit of extension of the lease period postulated under Section 80 of the MMDR Act is available, subject to a further overriding condition, namely that all the terms and conditions of the lease have been complied with. A leaseholder who does not satisfy any of the required conditions of the lease, as for instance, the postulated clearance, approvals, consent, which would not be entitled to the benefits extended under subsection 5 of Section 6 of Section A of the amended MMDR Act. So let's, the subject to the conditions, my lords, has been interpreted by the Supreme Court to say that it is further an overriding condition.
Yes.
So it's not automatic. Let's interpreting, referring to this particular paragraph in common cause. There's one other judgment, my lords, of Allahabad High Court. If I can just pass it on, my lords.
Yes.
Now, in this, the third judgment, Rameshwar Dutt, my lords, is a division bench judgment. My lords, running page 51, my lords.
Yes.
At para 64, in the context of the present case, it would be relevant to reproduce para 29, 30, and 31 of the judgment of the Supreme Court in the case of common cause. So that has been extracted. 31, my lords, if my lords may see page 52, emphasis has been supplied, specifically, my lords, with regard to the sentences I just now read out to my lords. Now kindly see page 53. That was a case where lease had expired, but observations are opposite. Para 71, para 71. I'm reading from para 71 to 77. In the present case, admittedly, the lease of the petitioner had expired on 15/6/1999. Thereafter, no lease deed was in existence. In such situation, it cannot be ascertained whether the petitioner has violated any terms and conditions of the lease. In a situation where lease deed has expired and an application has been submitted for renewal of the lease deed, and there is no lease deed in existence, but the petitioner continued to carry out mining operation without any lease, in such a situation, the court is supposed to lift the veil and find out the true intention of the legislature in incorporating the words, all the terms and conditions of the lease deed have been complied with. 73. In our opinion, the above mentioned words in section 8A6 have been incorporated with an intention that where renewal application has been submitted and order is yet to be passed, the mining operation should be carried out after complying with all the relevant provisions of the Act and the rules. And if there is non-compliance of any rule or provision of the Act, it implies that all the terms and conditions of the lease deed have not been complied with. The reason why we say so is that lease deed incorporates all the requirements of law on fulfilling of which the mining operation can be carried out. And if there is no lease deed in existence, then obviously the intention of the legislature is that mining operation should be conducted as per law. Even in the case of common cause supra, the Supreme Court has held that the benefit of 8A6 can be extended to those leaseholders whose applications have been found valid. The valid application means that application should conform with all the requirements of law, and if it's not in conformity with the law, such application cannot be said to be valid application of law. Now we proceed to analyze in the light of the aforesaid facts whether the petitioner has complied with the aforesaid requirements for availing the benefit of Section 8A6 of the Amended Act 2015. Now, my lords, on fact, later on they examined. Plus, that was a case, my lords, where the lease had expired, and if an application
was it a case for automatic extension?
Please, my lords, automatic extension. But if you had applied for renewal in time, but your application was pending, by that time your lease had expired. But then, my lords, these provisions came into force.
This provision is not under the consideration.
This provision is not under, but I'm referring.
In fact, their distinction, which there is a distinction between renewal and.
Renewal is a fresh grant.
Their case is not renewal.
Their case is not renewal. Milords, they had a valid registered existing lease as on 2023. Now it is an issue with regard to 23 to 3030. There is a deemed extension. The contention of the state government is that in principle there is an extension subject to certain conditions, including execution of a supplementary lease deed. Now, kindly, Milords, I'll point out the IBM letter, which also very specifically says that mining operation will be subject to execution of a supplementary lease deed. Can I just pass on that document, Milords?
Yes.
Page 3 of this compilation.
Yes.
Page 3. Now, this is the Indian Bureau of Mines, Milords, letter dated 7/3/2023. Their lease was valid till 19/2/23. This is after that, when there was an in-principle approval. Page 4, serial number 2, Milords, bottom of the page. The approval of review and updation of mining plan along with progressive mine closure plan is subject to the execution of supplementary mining lease deed for the extended period under the provisions of Section 8A of the Mines and Minerals Development and Regulation Act 2015 and the required statutory clearances from all the concerned authorities. Now, if my lords may take that compilation of judgments that I just gave now. The first judgment, I'll just read 2 paragraphs with regard to a mining lease. Page 10, running page 10, my lords.
Yes.
Para 31 and 37, I'll just read. 10.
Yes.
It is important to bear in mind that the term lease occurring in the definition of mining lease given in Section 3(6) of the Act 67 of 1957 does not appear to have been used in the narrow technical sense in which it is defined in Section 105 of the Transfer of Property Act, but as rightly pointed out by a bench of the Calcutta High Court in so and so, a settlement of the character of a mining lease is everywhere in India regarded as lease. A mining lease, therefore, may be meticulously and strictly satisfy in all cases all the characteristics of a lease as defined in the Transfer of Property Act. Nevertheless, in the legal accepted sense, it has always been regarded as a lease in this country. Now, para 37, next page. A right to carry on mining operations in land, to extract a specified mineral, and to remove and appropriate that mineral is a right to enjoy immovable property within the meaning of Section 105, more so when, as in the instant case, it is coupled with a right to be its exclusive KAS possession for a specified period. The right to enjoy immovable property spoken of in section 105 means that the right to enjoy the property in the manner in which that property can be enjoyed. If the subject matter of the lease is mineral land or sand mine, as in the case before us, it can only be enjoyed and occupied by the lessee by working it out as indicated in section 108, Transfer of Property Act, which regulates the rights and liabilities of lessors and lessees of the immovable property.
Yes.
Now, let's the next judgment, paragraph number 10 at running page 23 minutes. They in para 10 minutes, all the relevant provisions minutes of the Transfer of Property Act have been extracted, including the Registration Act, page 23, para 10. I'll just skip that para minutes just to point out that even section 17 of the Registration Act has been extracted. Minutes may see para 14 and first 10 lines of 15 minutes, page 28.
Yes.
Section 107 of the 1882 Act, which we have quoted above, stipulates that a lease of immovable property from year to year or for a term exceeding 1 year can be made only by a registered instrument. So far as section 106 of the said statute is concerned, in which distinction is made between lease of immovable property for agricultural manufacturing purpose and lease of immovable property for any other purpose, the same provides that a lease of immovable property for agricultural manufacturing purpose shall be deemed to be leased from year to year, terminable by 6 months notice. In other cases, termination would require 15 days notice. The subject agreement had a duration of 5 years with a provision for renewal for the further period of 5 years. Hence, under the first part of section 107, the said lease agreement to be admissible, registration of the same would have been necessary. The deeming provision of section 1 of section 106, so far as the same related to lease for agriculture or manufacturing purpose, would not be applicable as the same deed as the deed was not registered. 15. The appellant had argued that the trial court had admitted the lease agreement in evidence, and for determining the purpose of the lease, we can examine the deed. But this argument is flawed. This provision contemplates lease for manufacturing purpose in the absence of contract or local law, to the contrary, subject to a deemed to the year-to-year lease. In that case, it would require 6 months notice for termination. But here, the agreement itself provides for 5-year duration, and hence expressly becomes a document that requires compulsory registration. This is a mandate of section 107 of the 1882 Act and section 17 and 49 of the 1908 Act. This is the first 10 sentences of 15. Well, the submission is,
yes,
if my lords may see section 8A5 minutes,
yes,
the non-obstante clause is only with regard to subsections 2, 3 and subsections 4. It is not with regard to overriding the provisions of any other law.
yes.
8A5 minutes. Notwithstanding anything contained in subsection 2, 3 or 4, the period of lease granted before the commencement of the so-and-so Amendment Act 2015, where mineral is used for captive purpose, shall be extended and be extended to up to a period ending up to 31st of March 2030 with effect from the date of expiry of the period of renewal last made or till the completion of the renewal period, if any, or a period of 50 years from the date of the grant, whichever is later, subject to condition that all the terms and conditions of the lease have been complied with. My submission, my lords, is this. The non-obstante clause is only with regard to subsection 2, 3 and 4 of the very same section. It is not with regard to any other laws. So therefore, if you have to enter into the land and my lords, execute mining operations, then you need to have a valid lease.
No, lease is not in dispute.
Lease in 2023, my lords, lease expired. There is no
term of the lease.
Please, my lords.
What you're saying is to have a supplementary lease deed.
Please.
Showing that the term is X. They already have a lease.
They already have.
What is happening is by a statute, the period is extended.
By statute, it's extended. I'm sorry, please.
So by a statute, the period is extended of a lease. There is a registered document.
Please.
There is a registered lease.
Please.
The land is being affected by the lease and no other instrument.
Please.
So that instrument exists. It's a registered instrument. The issue on all that 8.5 does is extend that period by a deemed fiction. And you know that Lord Esquith's favorite, often quoted quote, that if you can't allow your mind to boggle where there is a legal fiction,
yes,
then all the putative things that must go with it, must go with it.
Yes.
That's the scope of a legal fiction.
Yes.
Therefore, if you are reading this section to mean this legal fiction means effectively now carry on everything else that you would necessarily have to do to execute a fresh lease.
Not a fresh lease.
It has to be, you
But
say
whatever
now
name.
execute a fresh lease, it'll have fresh terms, it'll have this extended term, it'll have all the clearances, it'll have everything else. Then what is the essential distinction of having this legal fiction brought into place?
Legal fiction is about entitlement. Kindly note this.
Legal fiction is about the term of the lease.
Then the legislature would not have
This
intended.
issue has not been decided anywhere else as to what is the import of the legal fiction.
The common cause, my lords, the previous para talk about
That's
that.
the only
But then, but then it comes to 31, my lords, and 31 says that notwithstanding what has been stated above,
that in any case, suppose your lease itself.
Please, my lords.
If you have a lease, that lease itself, you don't comply with the terms and conditions. Obviously, that lease is also subject to the terms of the lease.
Lease is always subject
also
to the
subject to it. It doesn't allow a person to mine if he is violating some terms of the lease.
He has to follow all the rules.
Correct. So that's in any case is there.
Please.
Does this according to you, this term gives you something more than what is otherwise already in place?
It does not give more than that. But
all that it means is that you will carry on your lease. Lease term is extended. But this doesn't take away from the fact that you have to comply with the terms of the lease.
The condition is your extension from 23 to 30 will depend on the lessee having complied with the terms of the lease till 23. That is the import, my lords. That determination is available to us, is what we are saying. My lords may say, subject to the condition that all terms and conditions of the lease have been complied with. That is, till he lawfully mined from till 23, there is a provision to determine that. Yeah. Otherwise, my lords, that subject to condition that all the terms and conditions of the have been complied with, my lords, that sentence will lose its. It will be rendered.
Nobody can claim that there is a deemed extension if he is otherwise fallen foul of the terms of the lease. I don't think there is any dispute cavil as to that.
We are saying that since we have given an in principle extension in terms of the deemed extension, subject to the fact that you clear all arrears and execute a supplementary.
You said you've given subject to has two meanings.
Please, minutes.
One meaning is that you do it, but you also have to do that. And the other is failing which you can't do anything. You have, in fact, your clause 4 of your
letter
especially say that you don't carry on mining unless you get these clearances. That means no mining except this clearance. No prohibition as far as other subject to clauses are concerned.
Look, that letter was issued much prior to, if my lords may see that letter.
You read, it's a government order you're talking about, not a letter.
A government order, I'm sorry, it's a government
order.
I stand correct.
You just read says that it says a grant in favor of so-and-so is extended to 31/3/2022 for a period of 50 years of the original grant. So now it is extended.
With the following conditions.
Subject to the following, with the following conditions.
With the
not
following.
even subject to the following.
Not even subject.
With the following. That means these conditions have to be complied with.
Please, minutes. Let's kindly note the date.
Deemed extension shall not absolve the lessee from any person claiming for it. So 2, the execution is on the director to execute.
Please, minutes.
So if anybody has not followed that condition, it's you.
No, he's directed to execute subject to submission. We are ready to execute if the
statutory clearances are given.
No, statutory clearances and all arrears.
So arrears, as far as
arrears, everything boils down
to arrears.
To the royalty, millards, and with regard to illegal mining.
If you look at the whole reading of this,
please, millards.
Rest all are conditions that you need, which need to be complied with.
Please.
But as far as mining activity is concerned, in a deemed extension, the only clause against non-carrying of mining activity is 4.
I would put it this way: the date of this government order is 25/8/2022. The last date, my lords, was they had up to 19/2/2023. So it was much prior to. It is not that this government order has been issued just when it was about to end. It was issued much in advance, and therefore, my lords, it has to be read in that context. Is my respectful submission. It was issued much in advance, so that within that time, by the time it is 19/2/2023, you could get all this.
Also said no mining operation undertaken in these
unless
a statutory clearance is
please,
obtained, and you name the statutory clearances that are required. That means don't carry on any mining activities from there. This is part of your one condition.
Please.
This is not attached to any of the other conditions. That no mining activity will be carried on until supplementary agreement is entered in. No mining activity will be carried on.
That clause is sort of interpreted against us, stating that just since we have put no mining operations, unless statutory clearances. That means you can carry on with statutory clearances is what we mean.
Means that now you've got a grant. You have to comply with so many things which you have to comply with. And this grant is not something that absolves you from complying with all that. But don't carry on any mining activities unless you get your environmental clearances, unless you get your notifications which are amended from time to time, satisfaction of the authority to the acts and rules.
Please.
So therefore, you please carry on only, nothing absolves you from complying with this, but you can't carry on, but still you comply with these conditions.
Yes.
Read with prima facie, we'll of course consider prima facie when you read this with a deemed extension, which means that you don't have to do anything else but deemed extension. And this is your grant. Then you must, to say that now you've carried on illegal mining, which you could not have carried on any mining activities despite a valid grant in your favor. Prima facie doesn't seem to wash.
Please, Minister, I'll
also
come
in context with the law which Supreme Court has laid in Gujarat Potteries, that this is only a ministerial act. Effectively, a lease is granted, the lease is active. This non-execution of the lease is only a ministerial act. Subject to correction, that's the ratio of that judgment.
Yes. I'll check it out. Let's, maybe we could have worded it better. Our own government order. Now let's we could have worded it better. Let's, but now it's 4 years down the line. We'll
retrospectively amend it. This is the reason why you can't retrospectively put penalty also. This is not about royalty. This is about penalizing something for an offence.
Insofar as royalty,
illegally raising.
Insofar as royalty impressions seems to have been given by the other side that as if everything was fine and we started to levy retrospective demand. The issue was live, Millards, from 95, 96 onwards. I'll point out a document itself.
The ramifications of it. There is a disputed question, which as of today, you have not prevailed. They have prevailed in that issue. As things stand today, it's your appeal.
It's my appeal, Millards.
While you are challenging appeal on non-payment of.
Even on that, it's only about quantification.
We accept your argument. Means there is the moment you have said something in your mind, everything else is illegal. Now entitles you to levy penalty, entitles you to say 5 times the penalty for doing so.
Yes.
And if you don't succeed, we don't know how contradictory that would be. You don't succeed in your appeal. Where are you?
The levy is gone.
Then what happens to your first two? That levy is correct. Your stand was incorrect of raising a demand. Your stand of withholding supplementary agreement was incorrect. But nonetheless, there must be a penalty of 5 times the amount.
I'll point
for illegal mining.
No, illegal mining, Millards, I'll come. That's a separate argument. I'll point out, Millards, what happened with illegal mining.
With costs, because this is the cost of judicial time that gets spent time and time again.
I'll be able to proceed, Millards. I'll be able to proceed when I take Millards insofar as the royalty aspect is concerned.
You're only putting it.
Please, Millards, insofar as the royalty aspect is concerned, I'll be able to point out their conduct. How, Millards, if they have been able to clinker, Millards, is what they generate. 1 unit of clinker, to generate 1 unit of clinker, you need 1.42 units of limestone. Now you have generated 1 unit of clinker. That is available in statutory data, Millards, that you have submitted to the statutory authorities, your returns that you have filed. Millards, they cannot, those statistics, Millards, are as of now finalized insofar as the production that happened. Without utilizing so much of limestone, they could not have produced so much of clinker. So it is the other way around. Now, at that point in time, they did not have a beltometer, and they had the weighbridge, Millards, also data, there was an issue there. I'll point out, Millards, from the report itself. Therefore, now, even in respect of that figure, since there were 3, now we have our committee, the committee, Millards, had given a figure of 400 odd crores with regard to the royalty demand that we had made, including the interest. Now, if I could take, Millards, to the central government order, we were given an opportunity to file our statement of objections. It reached them, Millards, the day previous to the order, but without considering that, Millards, an order has been passed.
We'll see when you argue your writ.
Please.
That is when you have to argue your writ.
Please, Millards.
This is on the other, there.
Please, Milords, can I just take my lords to the illegal mining aspect? Milords? There is one other.
Yes.
Milords, the mining period with regard to which, Milords, there is a dispute now is from 18/2/23 till 14/8/2024.
Yes.
Now, during this period, we are saying our contention is simple, Milords, no mining lease, so mining operations is illegal. Now, there is an intervening date, 21/11/23. So, 18/2/23 to 21/11/23, then 21/11/23 to 14/8/24.
Yes.
Milords, after the expiry of their original lease period, the ILMS, Milords, was not closed. So they continue to generate the permits, pay royalty, Milords, and transport the mineral. So we are saying even that is illegal. But since they have paid royalty, Milords, I would go to the next submission. 21/11/23 to 14/8/24. ILMS was closed.
Yes.
And Milords, they continued with mining operations and they transported the material and used it for captive consumption without payment of royalty, without permits. Now, even at least for this period, Milords, it will be totally illegal mining, I would say. Though 18/2/23 to till November, Milords, since they paid royalty, because on this royalty also is not paid. Now, the question would be whether I'm only entitled to claim the royalty or the value of the mineral under 21. Please see 21/5 Milords.
Without authority of law.
No, Milords, without authority of law, then there is an explanation, Milords. There's an explanation. Explanation says that on and from the date of the commencement of the Mines and Minerals Development and Regulation Act 2021, the expression raising, transporting, or causing to raise or transport any mineral without any lawful authority occurring in this section shall mean raising, transporting, or causing to raise or transport any mineral by a person without prospecting license, mining lease, or composite lease, or in contravention of the rules made under section 23C. So, Milords, under section 23C.
Where is this expression used?
Milords, explanation.
Defines an expression.
Please, Milords.
This expression is used in which main section?
Milords, 2.5.
2.5 doesn't use this
No,
expression.
2.5, it is after 2.6 Milords.
Explanation is for the whole section.
Please, Milords.
It says so.
Please.
That this in this term in this section.
Please.
That means this term must find its way somewhere in this section.
Please.
We're saying 21.5. 21.5 doesn't use this expression. It's in courts.
Please.
Only place where this expression is used is 21.4. So it defines, the explanation defines what 21.4 expression is. That means if they find that this is happening in your transporter, you can seize the vehicle, you can seize the pickle, you can seize the axe. It doesn't get into 21.5.
Please, Milords. Insofar as 21.5, Milords, I brought into that, Milords. 21.5 requires, Milords, a mining lease. Now, Milords, if the first argument is held against us.
If it's deemed, then the grant is an execution of a mining lease is a ministerial act as is held in Gujarat Pottery.
Please.
Then 21.5 goes out of the window.
Please.
Your explanation doesn't help you.
Please. But insofar as November to August, Milords, kindly note the conduct.
This is a penalty position. You don't put penalty. It's a statutory penalty. Either he falls into the penalty or he doesn't fall into the penalty.
No, Milords, because conduct is important because my lords also put to us.
He can be a very bad boy. We can't put a penalty under 21.5. He can be very good also, and if he's done something which falls foul of the side, he'll get it. That's all that we have to look at. Does he come under 21.5 or doesn't he come under 21.5? You tell us how he comes under 21.5, apart from the fact that he has no lease.
If I lose on the first argument, if it is held against me, Milords, then I don't have 21.5.
Then the explanation doesn't help you.
Please,
21 doesn't. So without authority of law, argument.
Please. Now, insofar as November to August 24, since even without payment of royalty, the stock has been lifted. Now, if there is a mining lease, if there is no mining lease, it's totally illegal.
If we accept your contention that
Please.
there was no lease at all,
Please, Manoj.
and they had no authority in law to mine, then you're right, then it's without authority of law. Then you straight away get to 21.5, 5 times the amount, value of mineral, everything else.
Please,
was
Manoj.
in place.
Plus, that will be our principal argument.
That's
With
the
regard-
only argument. Principle
Please.
is not. There's no ancillary argument to this.
Please, Manoj.
Either you are in it or you're out of it.
Please, Manoj.
Unless you tell us something else that we haven't thought of.
Manoj, I think that's our argument. And with
That is
re-
the principal argument.
please, that's the principal argument, and let's our stand. Not only that, Manoj, if I understand, Manoj, with regard to the Ministerial Act,
That argument we haven't heard an answer to you, Gujarat Pottery's answer we have not heard as well.
please, Manoj.
There is a ministerial act and done it, and that's the
Yes, sir.
decision of the Supreme Court.
I've not been able to lay my hands on that, Manoj.
Gujarat Potteries. Gujarat Potteries, have you placed?
AR 1967, 964, my lords, Gujarat Potteries. I have not placed it, my lords, because that was not their contention. But otherwise, it's SCR is AR 1967, one SCR 695. Gujarat Pottery. And that is still holding the field.
Gujarat?
Gujarat Pottery Works versus BP Sood.
Please.
To
Shall I go?
find it's only been distinguished in 3 cases. Gujarat Potteries, but none of them will help you. Unless you find some other case.
Please, Manoj. I'll just have a look on it.
I think one was B. Rudragowda.
Please.
Your lordship's
That's
judgment
what
in
the-
Delhi
in
High Court.
There's
Your
one
lordship,
more.
your lordships did not accept the Gujarat Potteries.
Manoj, I'll see, Manoj, if we can.
That was distinguished on
Please.
a different principle.
Manoj, we'll see.
Not on the principle of ministerial act.
Yes, Manoj. Manoj, I'll see if we can say something on that, Manoj, insofar as that is concerned. But insofar as the state's petition is concerned, Manoj may take our petition. That is 18-36850. Divisional Authority order challenge.
Yes.
Please, Manoj. It's in that the impugned order is at page 33, Manoj. 33. It's at 35. Notes of 35 minutes.
Yes.
Para 8 and 9 minutes. In this background, the present revision application has been filed by the applicant for setting aside the order dated 10/4/2024 passed by the state government, wherein the applicant was directed to pay an amount of rupees 792.41 crores. Thereafter, the revisionist has filed amended revision application dated 10/19/2025 against the demand notice dated 22/4/2025 issued by the Office of the Director, Department of Mines and Geology. Thereafter, if my lords may see, para 16, page number 37.
Yes.
Having examined the matter in the light of the submissions made by the parties and perused the available records, I observed as under. During the hearings, the revisionist presented that it had operated the payment system since beginning, and there is no evidence of any action or notices against the revisionist for irregularities in the measurement. The revisionist was also presented that during the year 2009, a beltometer was installed to weigh the total quantity of limestone and shale transported from mining lease to cement manufacturing plant, with reading furnished periodically. During the hearing dated 8/8/2025, a question was posed to the state government whether any notice given to the revisionist in past rejecting actual payment or any dispute relating to the beltometer reading either by the DMG or the legal so-and-so department after its installation during the year 2009. It's also observed that the limestone and shale consumption data for years 1993-94 to 2019 was validated by DMG, while a letter dated so-and-so, which is also presented to HLC. However, no documentary evidence relating to any dispute on the beltometer reading installed by the revisionist or reasons thereof rejection of actual measurement since 2009 till date, or an explanation regarding not considering DMG's own validated data dated 18/9/2000 has been submitted by the state government in spite of the directions by the undersigned from time to time. During the hearing dated 26/5/2025, the respondent was directed to submit whether the representative of the Indian Bureau of Mines submitted their views before the HLC or the efforts made by the state government thereof as per the government order dated so-and-so, and also recorded in the Honorable High Court order dated so-and-so. However, no comments have been received from the state government. The revisionist also argues that the entire framework for interest calculation was wrongly calculated and cited the repealed MCR 1960, which was reenacted as the MCR 2016. And accordingly, all interest calculations must follow Rule 49 of the MCR 2016, which should considerably reduce the demand to 137 crores. Para 18 minutes. The state government, via email dated 25/8/2025, has again requested for 1 week time extension to file their para-wise replies. However, even after providing 1 week extension as requested by the state government, no comments have been received so far. In the light of the aforesaid discussion, I conclude my findings as under. From the details submitted by the parties, it has been observed that there is no communication disputing the payment data since 2009. In fact, the DMG has also certified validated the payment details via a letter dated 18/9/2020. Unless the state government establishes the basis of rejecting the record maintained by the revisionist, it's not reasonable to reject the actual payment data and consider notional consumption factor. HLC report has also shows that the revisionist data is matching with DMG data in most of the period under dispute. Even the period prior to 2009 considered by HLC to raise doubt in measurement also don't demonstrate any substantial variation from the measured quantity. No satisfactory reason to reject the records maintained by the revisionist have been given in report before placing reliance to notional consumption factor, despite the fact that there is no dispute relating to beltometer readings or weighment data prior to that. In absence of any documentary evidence indicating disputes in weighment data, adoption of notional consumption factor in the assessment of limestone quantity in place of actual weighment data is not justified at all. Reasonable opportunity has been provided to the parties to submit their comments in the interest of natural justice. In the light of the aforesaid facts and circumstances, I am of the opinion, as a revisionary authority granted powers under Section 30 of the MMDR Act, remanding the aforesaid case back to the state government for suitable measures as pointed above in the interest of justice in accordance with law and also subject to pending court case if any. However, it is advisable, kindly note this notes, that while the matter is reconsidered by the state government, views of an independent organization, Indian Bureau of Mines, may be taken into consideration and to provide reasonable opportunity to the parties in the interest of principles of natural justice. Now, my lords, in this, we had, if my lords may see page 22, my lords, of our grounds. Para 24. The petitioner having, para 24 minutes, the petitioner having attended the hearing scheduled on 8/8/2025 through video conferencing, had assured to submit their statement of objections to the amended revision application within a period of 2 weeks from the date of the hearing, and the said request was also allowed. The petitioner had thereafter sent an email dated 25/8/2025 requesting another week's time to submit their para-wise comments. Thereafter, the petitioner has sent their statement of objection dated 2/9/2025, which was dispatched to register post on 3/9/2025 to the revisional authority. Though the statement of objection was received by the revisional authority on 8/9/25, the case of the petitioner as detailed in the statement of objection was not considered by the revision authority. Thus, the order that was passed by the revision authority without consideration of the statement of objection is liable to be set aside on this ground alone. This is our main ground. That, my lords, our objections have not been considered. Now, kindly note, my lords, this demand, which was part of the amended claim.
You attended the hearing. You asked for 2 weeks' time.
Please, my lords.
You asked for 1 week's time. Granted.
Granted.
Within,
please, within that we have sent it, my lords.
Not within that. You have dispatched it on 3/9. 1 week from 25 were expended on 2/9.
Please, my lords. It was received at least on 8/9, my lords.
It was received on 8/9.
Please, my lords.
Obviously, it would have received by if you send it by registered post at some dark place, dark counter. Filing counter doesn't traverse to the tribunal. The tribunal proceeds on the basis it doesn't have it.
It doesn't have it. But I'll
In
show.
any case, exceeded your time which was granted.
Let's
In
the
how will you fault? How do we fault a court or a tribunal by passing an order without by recording that they've given you time and you've not exceeded to it?
but
And that you were heard. You're only on principle of natural justice.
apart from that, Milords, even on findings, I'll be able to point out.
You tell us.
Please, Milords. Now, Milords, I've read the findings. Milords, the demand that was challenged by way of an amended revision application is dated 22/4/2025. This demand was based on the report of the high-level committee. Report is not under challenge.
Yes.
Now, while these proceedings, Milords, were pending before this honorable court, while the present proceedings were pending before this honorable court, we had issued a government order constituting this committee in view of, Milords, the divergence in the earlier demand that we had raised, which was fluctuating between 700 Milords to 200 crores odd. So therefore, Milords, the committee was constituted. Now the committee, Milords, has given a finding. The committee has gone, they were given an opportunity of being heard. IBM representative was part of the committee. Milords, he did not participate, Milords, and he gives a letter stating that, if Milords may see the grounds that I have raised, at the letter, if we para 27 of my grounds. Page 24 Milords.
Yes.
Let's para 27. Participation of IBM. Milords. The revisional authority has further observed that no comments have been received from the state government as to whether Indian Bureau of Mines submitted their views before the HLC, or any efforts were made by the state government to get the views of the IBM. It is submitted that HLC constituted by the government comprised 6 members, including a representative from IBM. The representatives of IBM did not participate in the proceedings for want of approval from the central government. In any event, the IBM in its letter dated 16/10/2024 had stated as under. In connection with the matter regarding payment of royalty, DMF and NMET as per the limestone proposed to be consumed, lies in the sole jurisdiction of the state government, and IBM has no jurisdiction in the matter, and this office has communicated the same via a letter dated 15/7/2024 and 19/9/2024. Therefore, once again, the matter is brought to your notice for further action. So one observation, Milords, is with regard to a representative of the IBM, Milords, to be part of the committee. That I have answered here, stating that they themselves have said we don't have a role. Though in the committee we had constituted, Milords, there was IBM representative.
Yes.
Now, Milords, in the remand order, the observation is that at page 39, para F, that it is advisable that while the matter is reconsidered by the state government, views of an independent organization, IBM, may be taken into consideration.
So it's open. You will get your.
No, Milords, what I'm saying is
this will be decided in case you have any evidence to show it.
No, Milords, I'll be able to point out in the memo, Milords, this issue, the fact, Milords, the finding, the main finding, Milords, of the regional authority is there has been no dispute with regard to the weighment or the measurement that has happened. That is what they are saying. But if Milords may see the memo that I had given today, I've just placed it on record as a convenience compilation, Milords, but this is all part of the HLC committee report annexures. Page number 2, Milords.
Yes.
From 99 onwards, Milords, the issue was from 1995. If my lords may see the subject there for a moment, 95, 96 to 98, 99. So it is with regard to these financial years. After 31st of March 98, 31st of March 99, Milords, there was an audit that took place where, Milords, shortfall, Milords, was flagged with regard to.
That's not the issue of shortfall. Shortfall, you have had any number of documents that you are producing where shortfall. The question is, what is the principle on measurement? Can you shift from actual measurement to notional measurement?
Please, Manoj.
Loyalty is only payable on dispatch and consumption.
Please, Manoj.
So you have to know what is consumption and what is dispatch.
Please.
There is a run of mine payment that is done. That's the point in which you, across the board, levy royalty. You are not levying royalty on that. You are now levying royalty on notional basis, assuming that the mining was incorrect.
Please, Manoj.
More quantity was mined than actually was shown.
Please.
And it was then consumed. That's why you're wanting a notional fact. I'm saying whether you should take a factor of 1.25, 1.5,
1.4,
whatever be the fact. They're saying when our equipment is functional and our beltometer is functioning, then you have measurements of actual. You've never challenged this actual that the beltometer is incorrect. That's what the tribunal is saying.
No, that's what the tribunal said, but beltometer was installed only in 2009.
So what happens about the other weighbridge? Is there any?
No, there was no weighbridge. That is our submission. I'll come to that. 90.
You show us from where you said that your measurement is incorrect or your system of measurement is incorrect. All the tribunal is faulting you with is that you've jumped to notional.
Without actually pointing out.
Without actually saying that this measurement is incorrect. First step of the way is that when you want to go to
a notional
way of doing so.
Actual is wrong.
Actually, assuming that a person has a tolerance limit in his production of 5% or 6%.
Please.
He can produce more of X by using less of or more of vice versa. Now, assuming that this is the case, you have to, before you jump and say, no, I will determine what your notional consumption would have been had your product, this is your production activity, then you have to come to the first conclusion that your method of measuring is incorrect.
Please.
Where have you pointed then that the way you're measuring is incorrect?
Please, I'll point out.
That's what the tribunal has said.
That's what the tribunal has said, but tribunal goes from 2009. 2009, Milord's beltometer was installed. Till 2009, no beltometer. There was no weighbridge that was installed, Milords, in.
That's why you're saying that there is no weighbridge.
Please, Milords.
You tell them a show cause notice, there is no weighbridge. How are you calculating it? Your officers are collecting a royalty.
Please.
They're certifying the amount that is being taken off from run of the mine. You're getting full returns of run. That's not your case that you're not getting the production returns.
Please.
You're getting your dispatch permits. You're issuing your on what quantity of ore is being taken place. Which at that stage, where have you pointed out?
Look, the first of the letters is in the year 1999. That is
only notional.
That is notional because we have disputed the actual.
Again, an inference. You went to notional because you inferred it was wrong, and now that you have issued notional, you are inferring you must have told them that your result is wrong.
No, it's for these three, 95, no, 96 from till 98, 99.
Show us one document, you called this fine. Show us one document where you said your way or calculation of dispatch is wrong. Your measurements are faulty. That's what the tribunal says. You haven't challenged their metrology.
No, it's tribunal's findings. No, if my Lord specific para 20, tribunal's finding is post 2009.
No, it says no metrology challenge. You show us a metrology challenge.
Para 20.
Yes.
It's para 20. First para is since 2009. Second para, they say even prior to 2009, considered by HLC to raise a doubt, also doesn't demonstrate any substantial variation in the measured quantity.
So there is a measured quantity. It's not reasonable to reject actual weighment data and consider notional consumption. That's the thought. And you are on 226.
No, weighment.
So what you're asking us is to say this principle is incorrect.
I will put it this. He did not have any material to say this, Milords. Rather, we had not our Milords. I pointed out, Milords, it was our fault also, Milords, that our statement of objections was delayed.
Don't invite us to start now giving rulings on actual issues. This is at 226.
Please.
State is in 226.
Please.
Is another. You must come to the conclusion that a tribunal is acted in a manner in complete disregard of the law. So the principle they've said is don't jump to notional till you find fault in the actuals.
Please.
You show us, and they said there's no fault on the actuals. You say this finding is incorrect. There is fault in actuals. Just show us one.
We'll look at the records, my lords. My lords may have it tomorrow.
All right, tomorrow, continue. Thomas, you'll have to give your central stand also on that.
I have, in fact, I wanted to produce this one communication. But this is on the implementation of APA 5 and 6.
APA 5 and 6. Otherwise,
Yes,
any dispute would make it. It's a very unusual situation.
Please have a look at the communication which the Government of India through the Ministry of Mines has sent. Got the page 2 is a communication addressed to the principal secretaries of all the mines department of all the states. It is dated 5th February 2015. Paragraph 3, if I may read. While all this is underway, it is requested that necessary action will kindly be taken to implement the provisions of the ordinance that can be implemented right away. More importantly, immediate action will be taken to implement the transition provisions of ordinance, subsection 5 and 6 of section 8A, which relate to extension of lease period up to 31st March 2030 for captive mines and up to 31st March 2020 for non-captive mines, and to issue the necessary orders amending the respective mining leases at the earliest, and at any rate, latest by 28th February 2015. A draft of the model letter that could be issued to the state government in this connection is enforced when they consider adopting the same if suitable to their requirement. It is needless to state that a prompt action on the part of the state government in pursuance of 8A5 and 8A6 will reopen the mines which have closed down and result in increase of mineral production for the state. And then, Lordship, I can see the draft letter which we have circulated along with this. And paragraph 2 of that draft letter says, as per the lease granted to you within so and so, the same was valid in so and so. In terms of the provisions of section 8A, 5 and 6, the period of your above mentioned lease now stands extended up to so and so date. Relevant lease date will stand modified accordingly. And then in 2022, we issued a further guidance because there were some queries on whether a supplementary should be executed or not. So we say, I am directed to refer to DO letter dated so and so of the state government of Gujarat regarding seeking guidance of this ministry regarding the model form of supplementary facility under section 8A, 5 and 6 of the MMDR Act. The matter has been examined in this ministry and it is observed that this ministry has issued DO letter dated 5 to which of 2015, which I just read out to my notes, to all the state governments sending a draft model letter for extension of mining leases under section 8A, 5 and 6. Copy of the letter is enclosed. State government will take appropriate action in the matter as per the above said DO letter 5 dated 5 to 2015 of this ministry. This is issued to the competent authority. Therefore, not asked.
But this doesn't include. You have the DO letter that you are referring to.
Page 3.
In this memo, you are referring to 14/12/2020.
No, the DO letter that is that the 14/12 must be the correspondence with the Gujarat government. But
DO letter is para 3.
DO letter is 5th February 2015.
That you 2015 letter is there.
Yes. 2015.
No, there is no, apart from this, there is no model supplementary lease.
No. In fact, our stand is very clear. There is no need of a supplementary agreement. Just a letter of extension will do. We have circulated the draft of the letter. And it is also.
What about stamp duties? Stamp duty has to be paid.
Yes, not.
And
yes.
Stamp duty has to be paid on your.
And that IB.
When you change the term of a lease, the stamp duty will change.
Yes, on that we have no stand on that.
Stamp duty they'll have to collect on the whether they do it.
State subject
whether they'll do it on the letter or not. Stamp duties you'll have to collect in the form.
But then the operations need not be stopped.
That is also their stand, except.
Let's department.
You got instructions that your stand is going to be the same in the other matters.
That's under minor mineral, they said, but the concept is the same. Dimmed extension, not science.
So you have to take one stand.
We have to, Milords.
Which is your stand?
No, Milords, I think when the next case comes up under the minor mineral, by that time we'll finalize that. Our issue.
Can't be that you can't take two stands. One
no,
for
we can't take. We can't blow hot and cold, Milords. We can't take
right.
Let's.
According to us, it defeats the legislative purpose of having a deemed extension if you want to make it a obstacle course once again.
Object itself, the object of bringing it is lost.
notes, but insofar as the central government letter, I have something to say on that. So we have just, it says a draft of the letter that could be used is what they say.
Obviously, they're only giving you a model. They're
Model,
not,
please.
they're not mandatory.
And but IBM, my lords, IBM approve, since IBM specifically refers to supplementary lease deed, I'll just point out to ASG.
Yes, sir, they are saying you're telling them that supplementary.
Instructions on that. Not the two letters that I read out are issued by the Government of India.
But even IBM, they have subsequently revised. It's a part of our pleading. My learned friend has not seen that. I'll point out after he completes.
So if the IBM letter is inconsistent with the stand of Government of India.
No, I don't think, Milords. I think IBM realized what my learned friend has posted with Milords and pointed out in the memo. It's a part of the pleading. Subsequently, they have issued a revision saying that this supplementary lease deed is subject to the writ proceedings. We have nothing to comment on that. And IBM is a part of the Ministry of Mines.
You come continue tomorrow,
please.
Let's one submission. The department are saying that they might want a slightly more accommodation.
What accommodation? They've given you how
I don't
many?
know.
No.
This has been going on for some.
That's at least day after. Day after.
Day after I have some.
They want to
difficulty.
inspect
We
the
have
records.
Samaj Parivartana day after in Supreme Court. Milords, it's almost done. I don't know on facts. We are not here, Milords. We are only on the question of law.
What time? What is the instruction that you want? This
This
is now put for a final hearing after.
It's only about that if there was any document.
That pottery you see, that's why we are adjourning it because we want you to.
Please, Milords, they have to just
Submission on that.
verify the record notes from the field officers.
We do intend to refer to that.
In fact, Milords have gone through their statement of objections filed in the revision which they have annexed to their writ petition. There also they have never contended there was no weighbridge. I think for the first time my learned friend's statement that there was no weighbridge.
But you'll take your instruction. That's the only thing. What else instruction?
Yes, that's the only thing, Milords. But they require it from the field officers, Milords.
Field officer will tell them what.
Milords, with regard, no, with the records, Milords, have been maintained. This is a 92-93.
You can't file a 226
it's
challenging one without doing a record and middle of it now decide whether there is record or not record and then you can find out.
It's 2 or 3 days.
Your submissions are made on the basis of the record. The record is not found out on the basis of the submissions that you make.
No,
the revisional authority, my lords.
There was no weighbridge is what we are saying. I'll point out.
Where are you saying it? You show us where you say there is no measurement.
The revisional authority has relied on a letter of the department dated 18/9/20, which records from 93-94 they validated. That is the only thing. Please see the weighment is validated. You show us when. Please.
We can put it day after tomorrow and you can take your chances.
Day after I have some difficulties. Samaj Parivartana is listed. Even either tomorrow or Milords.
Friday.
Please.
Friday, put it on Friday. Right. Come in first half, but
first
size your arguments to.
Please.
We are actually taking up your matter at the another part of the
Yes, a reservation matter.
Which you are also there in that.
Please. I'm for the public service.
Is that right?
My memo will be taken.
This is taken.
Number 18.
The interim order may kindly be extended.
Yes, they're not doing anything. At the request of the learned counsel, after some arguments, or after substantial arguments, the learned counsel, the senior counsel seeks time to take, seeks time to examine the decisions and takes instruction. This stop. Sorry, Mr. Verma, we wanted to take it up earlier, but I said, no, you're waiting. We wanted to take it up earlier, but time. You as well said. Yes.
I was on the question of the scope of judicial review of a legislation on affirmative action. Now, keeping the fact that we are reaching the case at this hour, I'll come back to that proposition after preparing a synopsis of the citations, which I want to present. And before that, may I just seek leave of the court to, I made the first proposition that the 50% rule stands obliterated by virtue of the 103rd Amendment.
That's right.
Now, in the alternative, I want to point out that even if the 50% rule is set to still hold good, that is not an inflexible rule, and there can be extraordinary situations or special or compelling reasons to depart from that rule. Now this, I want to point out that the impugned legislation was based on such extraordinary circumstances which warranted enactment of this provision enhancing the quota prescribed for scheduled castes and scheduled tribes. There are 5 such circumstances which warrant increase of quota in favor of the scheduled castes and scheduled tribes. The first one is the exponential growth of the population of scheduled castes and scheduled tribes. The second reason is increase in the number of scheduled castes and scheduled tribes over this period after the quota was fixed at 18%. And the third factor is, likewise, the backward classes also saw an exponential growth of the population. And increase in the number of castes that were added to the 32% quota which was fixed in their favor. And the fourth and more important factor is the empirical data that was collected to study the demand that was made by the scheduled castes and scheduled tribes for enhanced quota. Warranted an enhancement as reflected by 3 reports, namely Ratna Prabha Committee Report, Justice Nagmohan Das Committee Report, and Justice Subhash Reddy report. And the fifth factor is, I have already pointed out, Dr. B.R. Ambedkar on the floor of the Constituent Assembly spoke of minority of seats without reference to the minorities. The religious minorities were to be considered under the draft article 296, which specifically provided for it. Now, in the instant case, the minorities to a tune of 17% of the population has been added to this list. And therefore, they have to be eschewed from consideration of the 50% rule. These are the 5 factors on which I want to. Let me start with the first one, namely how the population may pass on the copies of the reports on which this legislation is based. Yes, even the copies. It is the petitioner's admitted case that the reservation has been 18% from the beginning. It is not in dispute. And from 1958, 18% was bifurcated between scheduled castes and scheduled tribes in the proportion of 15% and 3%. Kindly permit me to take the court straight away to Justice Nagmohan Das' report. Here I may make a statement that after the judgment in Pavitra 1, the government appointed a committee called under the chairmanship of the then Additional Chief Secretary, Srimati Ratnaprabha, who prepared and presented a report collecting the empirical data in respect of the scheduled castes and scheduled tribes. Which report was accepted by the government and a legislation was passed giving consequential seniority to the scheduled castes and scheduled tribes who stood promoted under the quota reserved for them. This was the subject matter of a decision of the Honorable Supreme Court in Pavitra 2. And the Honorable Supreme Court has endorsed this report and the data collected, as also the methodology used for collection of this data in its entirety.
Yes.
Justice Nagmohan Das has not only utilized this data furnished by Ratnaprabha Committee, but has also independently examined certain aspects.
Yes.
He has updated this data And based on this data, empirical data, he has recommended enhancement of the quota. Yes.
Yes.
Justice Subhash Reddy has endorsed this recommendation and has also opined that the quota needs to be enhanced. I'll take the quote through the reports later, but before that, may I just come back to the first proposition, why this is an extraordinary case. That is the explosion of the population of the scheduled caste. Kindly come to para 190, page 199 of the report. Justice, at page 252.
Yes.
There is a tabular statement, table 8.2, which reflects the growth of the population. Page 252.
Yes.
In para 2.1, the growth of SC/ST population from 1961 to 2011 and the projected population for 2021. That is how it reads, caption. First, I'll refer the table. Kindly permit me to show serial number 1 relates to the census data of 1961.
Yes.
The population details are given and the percentage of the population of the scheduled caste in 1961 was 13.21. This is the census data, unimpeachable census data, and the corresponding population of the scheduled tribes was 0.81. And the quota fixed for them was 15 and 3 in 1961. From then onwards, every decennial census, the data is given. There is a steady growth. Kindly come to 1981. This is very important. 1981.
Yes.
From 13%, the scheduled caste population went up to 15%. And the scheduled tribe population from 0.81, it shot up to 4.9. But the quota remained the same, 15 and 3, even after 1981. Thereafterwards, I'll straight away take the quote to the last census that is available, 2011 census. The percentage of population of the scheduled caste as per the 2011 census in Karnataka was 17.15%. 17.15 as against 13.21 that was prevailing when 15% was fixed. Likewise, the scheduled tribe population exponentially grew, it literally multiplied from 0.81 to 6.95.
Yes.
But the quota remained at 3%.
Yes.
Kindly permit me to take the quote to the next page. Justice Nagmohan Das committee has also taken the growth of the decennial growth of the population and has projected the population for the year 2020 kindly permit me to say, the report was submitted in 2020. So, it projected the population till the date of the presentation of the report at 17.98 and 7.41. Kindly mark, this is very crucial.
Which page are you referring to?
This will be table 8.3 at page 253.
Yeah.
At page 253.
Yeah. So 18 and 7.5.
Yes. So 18, yes, 18 and 7. I go down to that. It is 18 and 7.5. In other words, for a population of 25.5, the quota stagnates at 15 and 3 respectively. So this is the first extraordinary circumstance.
Then your suggestion can't be that it must be proportionate.
No, I'm not saying it is. It should be
With
proportionate.
18% and 7.5 means 25. According to you,
No, we have still not given. Even now, we have not given proportional representation. We have still not given proportionate representation. All that I am stating is that even after an exponential growth of the population of both the scheduled castes and scheduled tribes, there was no enhancement of the percentage of reservation in their favor. Because population is a relevant factor. I'll also show the authorities. Population need not be proportionate. It has to be adequate. I respectfully agree. But at the same time, the population of the scheduled castes and scheduled tribes is a very important and relevant factor to be considered for fixing the quota in their favor. So this is the first circumstance, extraordinary circumstance, which has warranted the. The second extraordinary circumstance is also appreciated by the committee, Nagmohan Das committee. Kindly come to page 243. Sir, on the day 15% and 3% quota was fixed, respectively, the total number of castes in the list of scheduled castes, as per the presidential notification under Article 341, was 6, namely Adi Dravida, Adi Karnataka, page 243. There is a at page 244, the relevant para is there. Scheduled castes and scheduled tribes list during pre-unification period. In the Indian Republic, the power to include or exclude castes and tribes into the lists concerned rests with the President of India. The names of these castes and tribes are not to be written in vernacular language. As per the order declared on 10th August 1959, there were 6 scheduled castes which were eligible for reservation. Similarly, the order issued on September 6, 1956, 6 scheduled tribes were eligible for reservation. They are as follows. Scheduled castes, Adi Dravida, 2, Adi Karnataka, 3, Banjara or Lambani, 4, Bovi, 5, Koracha, and 6, Korama. These were the 6 castes which were included in the list of scheduled castes under Article 341 by the Parliament. And the number of scheduled tribes was also 6, namely Asalaru, Iruliga, Jenukuruba, Kadukuruba, 5, Malairu, and 6, Soligaru. Yes. The committee has taken pains to chronologically record how new castes were added, new tribes were added, yes. I have prepared a compendium to show all the parliamentary enactments which have added these castes, and I may kindly be permitted to place it before the court.
No, we'll take your note of your submissions.
Yes.
There have been addition.
Yes.
Unless you say that there's something more than 245.
No. Yeah, all that I want to say is they are all acts of parliament which have added these castes, and today court may kindly record this statement that the number of castes in the list of scheduled castes
Yes.
is 101 as against 6 that was there, and the quota was fixed at 15%. So 6% quota has 15% quota fixed for 6 castes continues to stagnate even after the list became 101 castes.
Yes.
Yeah, I am placing those parliamentary enactments, copies given to me. Likewise, the scheduled tribes also underwent an exponential growth, and the number of tribes and or parts of tribes that are now added to the list, from 6, it has gone up to 50.
Yes. Yes.
One major factor which has boosted the population of the people, I request the court to kindly permit me to show one enactment. This is in the enactments of scheduled castes. I have placed all the orders. Kindly come to page 65 of that compilation.
Yes.
The Scheduled Castes and Scheduled Tribes Orders Amendment Act of 1976.
Yes.
Sir, this was brought into force with effect from 27/7/1977.
Yes.
Now, court may kindly take this fact into consideration. 1965, a committee was constituted, namely Lokur Committee, to go into the revision of the list of scheduled castes. 1965, it presented the report, based on which a bill was also introduced to amend the list of scheduled castes. However, it was referred to the select committee and the Lok Sabha was dissolved in 1971 and that bill did not see the light of the day thereafter. But instead of revising the list, by this 1976, what was done was the area restrictions that were placed earlier were removed, and the consequence of it was Karnataka, which composed of 5 different units, namely Bombay Karnataka area, Hyderabad Karnataka area, Old Mysore state, Kodagu, and Madras Karnataka area. There were 5 separate lists. Now, in all the 5 lists, there were several names which are not common. And by this act, with effect from 27/7/1977, the area restriction was removed and the castes or tribes which were only scheduled castes or scheduled tribes in pockets came to enjoy the status of a scheduled caste or scheduled tribe throughout the state of Karnataka. That is the reason why the population of the scheduled castes and scheduled tribes, we find such a sudden explosion of their population after 1977, and it is reflected in the 1981 census data. So that is the second strong reason why the quota needs to be increased.
Please continue.
Please.